Labor unions only represent in the private sector about 6.6% of the private sector workforce. People think that they don't have any rights under the NLRA because they're not represented by a union. But as long as you're an employee or a misclassified contractor, right? If you are misclassified as a contractor and really factually are an employee, then you have the right to collective bargaining, to get together with other workers in concerted activities for your own mutual aid and protection.
I think people would be surprised to hear that you have certain rights even if you're not unionized. So can you talk about the rights of workers who aren't unionized?
So you have to be an employee to be covered by the NLRA, Title VII, OSHA, workers' comp. Every sort of statutory system that's out there depends upon this classification as an employee, right? And so that is the beginning, right, in terms of having protection under the National Labor Relations Act to walk out for better wages, hours, and working conditions, like the workplace is too cold, or there's safety problems, or there's sexual harassment or discrimination going on. Those are all wages, hours, and working conditions that workers can complain about and not be retaliated against. But in terms of the safety issues, right, if a couple of employees feel like the PPE is not sufficient, or there's people are allowed to go into the workplace without a mask, the employer should have a mask rule, or there's not distancing in a restaurant, in terms of the tables, they can walk out of the job. And usually, if you walk out or go on strike, you can be permanently replaced, but you still maintain your employee status. You may have the right to reinstatement or back pay from your employer. There's also under OSHA, the right to walk out over abnormally dangerous circumstances. You may only be one person, right? That may not depend upon having other workers join you in your action. And again, in a healthcare facility, it might be very different than a restaurant, and so it's going to be very factual. A factual circumstance that I have to keep the caveat: every factual circumstance will be different, and this is again not advice that everyone should take generally.
Yeah, it does seem like the NLRA offers better protection, provided that workers know that they need to work with others to lobby for these improvements in safety, not just do it on their own.
In fact, that the statute itself says that individual workers are commonly helpless to negotiate fair working conditions. They have to join with other workers in order to have collective power. What we've seen in this country is the individualization of so much of our labor and employment laws that many people assume that it has to be just about them in order to have any protection. But in general, again, in the 1930s, Congress designed the statute with that in mind, and with some rare exceptions, you have to have another worker join you in concerted activity.